Welcome to Landlord Self-Help Center's Landlord Education Series. I would like to introduce my colleagues and myself, Silvana Agostino, Alda Pereira, Carolina Rego, and myself, Diana Padierna. We're community legal workers at the Landlord Self-Help Center and will be providing today's presentation, which will address the topic of LTB applications post-tenancy. This presentation offers general information only, not legal advice. Please be aware that we will be recording this presentation, so click on accept in the pop-up. There will also be a question period at the end of the presentation. We will be answering the questions previously received, so thank you very much for sending them to our email address. Also, please keep yourselves muted during this presentation. In Ontario, the Residential Tenancies Act is a provincial law that governs most residential rental agreements. It defines the rights and responsibilities of both landlords and tenants and outlines the rules and procedures for filing post-tenancy applications with the Landlord and Tenant Board against former tenants. Bill 184, Protecting Tenants and Strengthening Community Housing Act 2020, was proclaimed into force on July 21st, 2020, and received royal assent on the same day. However, numerous outstanding amendments were proclaimed into force on September 1st, 2021, including the now clear jurisdiction of the Landlord and Tenant Board over post-tenancy applications against former tenants. This only applies to post-tenancy applications where tenants moved out of the rental unit on or after September 1st, 2021. According to the changes made to the Residential Tenancies Act as a result of Bill 184, landlords have 1 year to file a post-tenancy application from the date their tenant vacated the rental unit. Landlords will have to know where their tenants currently live in order to proceed with this type of applications. Landlords may have to hire their services of a private investigator or a skip trace agency in order to find the tenant's current address. Unlike other applications to the board, landlords will have to give a copy of the L10 application and a notice of hearing package to the tenant at least 30 days prior to the hearing date. I will now pass it on to my colleague Silvana so she can expand on the L10 application.
Thank you, Diana. Okay, the L10 application, as of September 1st, 2021, the L10 application can be filed with the Landlord and Tenant Board for post-tenancy issues such as arrears of rent, compensation, unpaid utilities, damages, and other incurred costs as a result of the tenant's behavior. Prior to this, if a tenant vacated owing arrears of rent, the only remedy for a landlord would be to sue in small claims court. Rent arrears. If the tenant has moved out of your rental unit owing rent arrears, and the landlord wants to obtain an order requiring the tenant to pay the rent arrears, the landlord may file an L10 application to collect rent the former tenant owes along with any NSF charges. In order to file this application, the tenant must have moved out of the rental unit on or after September 1st, 2021, and this application cannot be filed more than 1 year after the tenant moved out. Compensation. A landlord may apply to the board for an order requiring a tenant or a former tenant to pay compensation for use of occupation of the rental unit after a notice of termination or an agreement to terminate the tenancy has taken effect. The former tenant may be ordered to pay compensation for each day they lived in the rental unit after the tenancy was terminated by a notice of termination or an agreement to terminate. Again, the tenant must have moved out of the rental unit on or after September 1st, 2021, and the landlord has 1 year to file this application from when the tenant vacated. This image shows part 4, reason 1 of the L10 application. This is the section that you would complete that pertains to the rent amount owed by the tenant and compensation for each day they remained in the unit after the date of termination. This image shows part 4, reason 2 of the L10 application that must be completed to collect any amount for NSF checks the former tenant gave you. The table shows you to fill out the amount charged by the bank plus an administrative fee of $20 per check. Thank you, and now I will pass it over to Carolina.
Thank you, Silvana. According to Section 88.2, subsection 1, landlords are allowed to file an application for compensation for failure to pay utility costs against a current or former tenant. Up until September 1st of this year, the Landlord and Tenant Board could only terminate the tenancy based on this issue, but did not have the jurisdiction to issue an order determining the amount owed in utility costs by the tenant. Now the landlord can file an application while the tenant is residing at the rental unit, or in the case of a former tenant, the landlord has 1 year to file this application from the date the tenant vacated the unit. Once the board issues the order, they will deduct the utility costs owed to the landlord from the last month's rent deposit or interest owed to the tenant. The continuation of Section 88.2 allows landlords to recover costs associated with out-of-pocket expenses that are incurred as a result of a tenant or former tenant's failure to pay utility costs. This section also applies to costs associated with the tenant's failure to pay for utility bills or out-of-pocket expenses incurred before the proclamation date of this section. This image shows the Reason 3 section of the L10, which deals with unpaid utility bills by a former tenant. If this is not enough room for the landlord to list all of the outstanding utility costs, additional sheets can be attached to the application. It's a good idea to model the chart provided here on your attached sheets if possible. The total owing listed on the application should be the amount owing for all outstanding utility costs. It's also best to justify the amount of out-of-pocket expenses you are claiming in this section by attaching detailed receipts or invoices for each expense. The L10 form provides additional space, so you can include further information about the unpaid utility bills. Additional information in this section would include details and copies of all outstanding utility expenses the landlord is claiming. Next is damages. According to Section 89, landlords are allowed to file an application for compensation for damage against a current or former tenant. The landlord can file the L2 application while the tenant is residing at the rental unit, or in the case of a former tenant, the landlord has 1 year to file the L10 application from the date the tenant vacated the unit. Once the board issues an order based on this, compensation for damage owed to the landlord will be deducted from the last month's rent deposit or interest owed to the tenant. The continuation of Section 89 allows landlords to recover costs incurred as a result of the damages caused by the current or former tenant. This section also applies to the costs incurred before the proclamation date. This image shows you section of the L10 under Reason 4 with respect to damages caused by a former tenant. It's important to outline the damage in as much detail as possible. Itemize everything. Make sure to explain each occurrence of damage and the costs associated with replacement or repair of the item. Attach as many pages as you need for this section, including copies of receipts or invoices. Now, Alda will continue with the discussion about interference.
Thank you, Carolina. Application for interference with reasonable enjoyment, lawful right, privilege, or interest. As per section 88.1, subsection 1, landlords will be allowed to file an application for compensation based on interference with their reasonable enjoyment, lawful right, privilege, or interest. They can file against the current or former tenant. Up until now, the Landlord and Tenant Board could only terminate the tenancy based on this, but did not have the jurisdiction to issue an order determining the amount owed as compensation for interference with the landlord's reasonable enjoyment, lawful right, privilege, or interest. The landlord can file this application while the tenant is residing at the rental unit, or in the case of a former tenant. The landlord has 1 year to file this application from the date the tenant vacated the rental unit. Once the board issues an order based on this, the board will deduct the compensation owed to the landlord from the last month's rent deposit or interest owed to the tenant. Compensation for interference with reasonable enjoyment. This is the continuation of section 88.1, which allows landlords to recover costs associated with out-of-pocket expenses incurred as a result of interference by the current or former tenant. This section also applies to an interference by the tenant or out-of-pocket expenses incurred before September 1st, 2021, which is the proclamation date of this section. The image here shows you the section of the L10 under reason 5 with respect to interference with the reasonable enjoyment, lawful right, privilege, or interest against a former tenant, whose behavior led to the landlord incurring additional expenses. Some examples of this behavior include a tenant pulling a false fire alarm, which may have led to the landlord being fined by the fire department. Or another example would be constant attempts by the landlord to enter the rental unit in order to treat it by pest control, which then may have led the landlord to incur extra costs. According to section 189.0.1, landlords who apply to the Landlord and Tenant Board based on arrears of rent, compensation for use and occupation of the rental unit, compensation for interference with reasonable enjoyment, compensation for failure to pay utility costs, and damages against the current or former tenant, will have to provide a copy of the actual application and notice of hearing to the tenant in question. The landlord will then have to fill out a certificate of service to prove that copies of those documents were given to the tenant in question. Please remember that a copy of the L10 application and the notice of hearing package has to be given to the tenant at least 30 days prior to the hearing date. Section 191 indicates the approved methods of service when delivering notices or documents to a tenant or former tenant who is no longer residing at the rental unit. Landlords can serve tenants in person by giving the document to the tenant directly, or to an apparently adult person where the tenant or former tenant lives, by regular mail to the address where the tenant or former tenant lives, or by any other means allowed in the Landlord and Tenant Board rules. Thank you. Back to Diana.
Thank you, Alda. It's very important to educate yourself and gather information about various topics related to renting. Use resources found on the Landlord and Tenant Board and Landlord Self-Help Center's websites to help guide you. The Landlord and Tenant Board website has links to instructions for many of their notices and applications, as well as interpretation guidelines, which provide more information about the decision process. Thank you so much for your attention. We will now address your questions. Please remember that we are answering questions previously received, so thank you so much for sending them to our email address. So if you did not get an opportunity to ask your question today, somebody else most likely previously sent a question similar to yours, and we will be answering it today. The first question that we received says, I am a landlord trying to file a claim against my tenant, but I do not know where she moved to. What do I do if I don't know where my tenant is currently living? Silvana, would you like to answer that, please?
Sure, Diana. In this case, the landlord may need to hire a private investigator or a skip tracing agency to try to track the tenant down. Depending on how much the former tenant would owe you, it may not be worth your while to go after them.
Thank you, Silvana. The next question says, how can I arrange to watch other Landlord and Tenant Board hearings in advance? Alda, would you like to answer that, please?
Okay, sure. Landlords can call the Landlord and Tenant Board about the hearing. Sorry, they can call the Landlord and Tenant Board at 1-888-332-3234 or send an email to ltb@ontario.ca and ask about obtaining the hearing links.
Thank you so much, Alda. The next question says, my lease says I can charge $50 for a non-sufficient funds or NSF check administration fee, but I see the application says $20. Is it okay to charge the $50 since it's part of my lease agreement? Carolina, would you like to answer that, please?
Sure. No, the Residential Tenancies Act sets a minimum administration fee of $20. So you cannot legally ask for more than that, even if the tenant agreed to the higher amount when they signed the lease. The next question says, my tenant vacated but left behind lots of damage in the rental unit. I want to file a claim against them for damages. What is the best way to determine the cost of repair if I haven't done repairs to the unit yet? Diana, would you like to answer this?
Yes. Yeah, so my recommendation is for landlords to prepare themselves and get at least 2 estimates of each item that needs to be repaired or replaced. Once you have all the information, including the former tenant's new address, you can file the L10 application with the Landlord and Tenant Board. Okay, so the next question says, my tenant moved out before September 1st, 2021. Can I still file the L10 for damages? Silvana, would you like to answer that, please?
Sure, Diana. No, unfortunately, because your tenant moved out prior to September 1st, 2021, you cannot file the L10 application. You would have instead to file a claim in small claims court.
Thank you, Silvana. The next question says, my tenant vacated after September 1st, 2021, and did not provide me with 60 days notice as per the Residential Tenancies Act. Can I use the L10 application to recover the rent they owe me? Alda, would you like to answer that, please?
Sure. Yes, you can file the L10 application, but you must show that you tried to mitigate your losses by trying to re-rent the unit to a new tenant as soon as possible.
Thank you. The next question says, can I file the L10 now against my current tenant? Carolina, would you like to answer that, please?
Sure. No, the L10 application is meant to be filed against former tenants only. So if you have an issue with damages, unpaid utilities, or interference with your current tenant, you can look into serving the proper legal notice of termination and then completing the L2 application to the Landlord and Tenant Board. The next question says, my tenant moved out after September 1st, 2021, and owes me money for non-payment of rent and damages. I am in the process of hiring a private investigator to find my tenant's current address. However, the investigator says that it could take months to find my tenant. How long do I have in order to file the L10 application against my former tenant? Diana, would you like to answer this?
Sure. So please keep in mind that you have 1 year after the tenant moved out to file the L10 application. So if more than 1 year has passed since the tenant moved out of your rental unit, you can no longer file the L10 application with the Landlord and Tenant Board. The next question says, my rental unit is located at a condo building. My tenant's son and friends pulled the fire alarm of the building as a prank, and the fire department showed up and issued me a fine because I'm the landlord and the owner of the property. My tenant and her family then moved out without compensating me for this fine. What can I do? Silvana, would you like to answer that, please?
Sure. If the tenant and her family moved out on or after September 1st, 2021, the landlord is able to file an L10 application under substantial interfering for pulling the fire alarm as a prank to recover the costs of the fine that they received.
Thank you, Silvana. The next question says, if I don't know my tenant's current address, can I file the L10 application with the Landlord and Tenant Board and then look for the tenant after? Alda, would you like to answer that, please?
Okay. Yes, you can initially file the L10 application without the former tenant's current address. However, you will have to explain at the hearing how you determine the former tenant's current address to deliver the notice of hearing package. It will then be up to the board member to determine whether to allow the application.
Thank you, Alda. The next question says, is there a deadline to submit all the evidence pertaining to the L10 application? If so, what is the deadline? Is there a special format to follow when submitting the evidence? Carolina, would you like to answer that, please?
Sure, Diana. So according to the Landlord and Tenant Board practice directions, unless the Landlord and Tenant Board orders otherwise, all parties must provide the other party with a complete copy of the evidence that they intend to rely upon at least 7 days before the hearing, or 5 days or 5 days if you're responding to the application. In terms of the format, all the evidence must be readable, have consecutively numbered pages, and if there are more than one item being submitted, include a list or table of content identifying each item in order and by page number. And the last question says, how do we file the L10 application with the Landlord and Tenant Board? Is it possible to file it by email and pay online? Diana, would you like to take this?
Yes, thank you. So the Landlord and Tenant Board is currently working to enhance their website and allow landlords to file all applications online. However, they're currently accepting L10 applications by mail or courier. You can courier or mail the application to your closest LTB location. In order to find the closest LTB location to your property or to where you live, you can visit the website of the Landlord and Tenant Board, which is tribunalsontario.ca/LTB, or call them at 416-645-8080 or 1-888-332-3234. If you courier or mail your application, you can pay the application fee by a certified check or money order, Visa or MasterCard. We also know that the Landlord and Tenant Board offices are not open due to the COVID-19 pandemic, so it is not possible to file the applications right now in person at this time. Okay, and that's it for the question period. On behalf of the Landlord Self-Help Center, thank you so much for attending this presentation about LTB applications post-tenancy. We look forward to see you in our upcoming presentations. Bye, everyone.